Good afternoon. Rules Committee will come to order, and thank you very much for joining us. Today we will continue amendment consideration of H.R. 5293, the Department of Defense Appropriations Act of 2017. And it's our witnesses will be coming and going. The members are aware that we're involved in a classified briefing right now that is in the Visitor Center that is concerning the events that occurred in Orlando, Florida over the weekend. And I have just returned from that hearing, as well as the gentleman, Mr. Stivers, who will be here in a minute. I note that we have a number of our members that, in fact, are not here yet, but will be here. We will await through proper hours to allow every member a chance not only to finish that briefing, but also a chance to come back and be with us today. But I feel like it's important for us to move forward, and so we will take witnesses as they come. Does the gentleman from Florida have any opening statement you wish to make? Gentleman does not. I've discussed with the gentleman our desire to go ahead and begin moving. The gentleman has said that's the right thing to do. I want to thank the members of the committee that are here. Mr. Byrne, Chairman Cole, thank you very much. The chair will now welcome the gentleman from North Carolina, the gentleman Walter Jones. The gentleman is recognized, and just so we really understand this, I'll be giving unanimous consent to everybody to insert the things that they choose. The gentleman is now.
This is Mr. McGovern's amendment, which I am a co-sponsor and want to help him.
That would be awesome. Yes, sir.
In the briefing, I was just told, Mr. Chairman.
Yes, sir.
Here shortly.
Mr. Jones, I would allow you to speak as you choose. We will also allow Mr. McGovern. Thank you for notifying us. If you do me a favor and tell me what number that is, as you know, we have some.
The amendment is 5293.
Number 16, I hear. 64, thank you very much. So amendment number 64. And Mr. Jones, I'm going to welcome you to please not only turn on that microphone. We've now turned to number 64, and the gentleman's recognized.
Mr. Chairman, thank you very much. And I want to thank Mr. McGovern for working with me for a number of years now on the fact that we as a member of Congress have no other responsibility as important as debating whether we send our young men and women to war to give their life for this country. The reason that I joined Mr. McGovern in this is that we have not had a debate on an AUMF since 2002. That was the last time the Congress actually debated an AUMF authorization of military force. That, to me, is, for myself personally, I am not meeting my oath of office when I swore to uphold the Constitution. Second to that, the frustration by many of us in both parties, and it is both parties, that we wrote 5 letters to Mr. Boehner when he was Speaker of the House, asking Mr. Boehner to please allow us to meet our constitutional responsibility. Mr. Boehner, while Speaker of the House, said that he would wait for President Obama to submit an AUMF, an authorization of military force. Mr. Obama, the president, did send an AUMF. Now, obviously, everyone on this committee knows better than I that when the AUMF came from the president, it would be sent to the Committee of Jurisdiction. They could change, they could modify, they could do anything they wanted to, use that as the vehicle to get it to the floor of the House. Nothing happened. Since that time, we have written 3 letters to the new Speaker, Paul Ryan, asking him for the same privilege that we asked Mr. Boehner to allow us to meet our constitutional responsibility. I would further state that it is so disappointing that we have not had this debate yet. James Madison said it much better than I've said in my few comments. The power to declare war, including the power of judging the causes of war, is fully and exclusively vested in the legislature, not in the executive branch, but in the legislative branch. So I hope that you will make this amendment in order that Mr. McGovern has offered, and I am the Republican co-sponsor of this amendment, that would basically say that until we have this debate, that we would not fund the continuation of any of this until we meet our constitutional responsibility. And I hope that this committee will put this amendment in order so that we can have this kind of debate on the floor of the House. Last point on this, very quickly. Ash Carter, the Secretary of Defense, spoke to the Armed Services Committee, which I serve on, about 4 or 5 months ago, and my question to Secretary Carter was, sir, do you think we need to have a debate and to pass a new authorization of military force? His answer was to me, sir, I do not think it's my place to tell the Congress what to do. He said, but I will tell you this, it would mean so much to our troops overseas who are giving their life for this country to know that their Congress does support them being there. So that's the close of my comments, sir.
Thank you very much. I would note in looking at the bill does not necessarily satisfy the desire that you have to have an AUMF, but simply you're saying that it would limit the funds. So this would be a limiting amendment.
Right.
That you're offering.
Right.
Which would, I believe, help further the cause of an answer, of a determination of the body, asking the members where they were, at least on the issue. So I think that this is a wise, fair opportunity that you have, Mr. Jones. I've known you not only for a number of years, but known you to be a fair and equitable man. I also know that you're, so to speak, in the lion's keeper as you represent so many members of the United States military, including the proud members of the United States Marine Corps. And I want to thank you not only for being here today and joining Mr. McGovern, but the committee will give due consideration of this. And I would defer, if I can't have you stay now, Chairman Cole, do you seek time?
Just quickly, I
Recognized.
want to thank my friend. I've signed a lot of those letters with him, and I believe, I'm not sure I would support the amendment in terms of cutting the funding off, but it's certainly an appropriate thing that we ought to be talking about. And as my friend knows, I've gotten up in our conference on a number of occasions, just as he has, and argued under the last speaker and the current speaker that this needs to be resolved, that this needs to be to come to the floor. I think we're involved in what I would consider an unconstitutional war. Now, the administration wouldn't take that view. They think they have the authority anyway. I don't really think they do. I wasn't here in 2002, and most of this Congress was not here. And I don't believe the people that voted on it believed they were giving any administration, let alone 2 in a row, the ability to go to war essentially anytime, any place they wanted to. And if that's what that authorization did, then it needs to be repealed and needs to be looked at. And I think the members owe their constituents putting their fingerprints on these kind of decisions. And they certainly owe it to the men and women, as my friend suggested, they're in the fight. They need to know it's a constitutional fight, and they need to know the American people are behind it, or they need not to be there, one or the other. But they shouldn't be there in this, I consider, legal limbo. So I appreciate my good friend's passion and commitment on this, and I think he's doing the right thing. So with that, I yield back.
Chairman yields back his time. Thank you very much. Gentleman from Florida.
Thank you very much, Mr. Chairman. Mr. Chairman, I echo your sentiments regarding our friend, our good friend, Mr. Jones, and I thank him for bringing this measure. I agree with everything that my good friend from Oklahoma said, with the exception of I'm not opposed to the restriction, because I think something needs to be done. As my friend from Oklahoma said, I believe I'm on either all 5 or certainly 4 of the letters that have been offered up to our speakers, and ask that this measure be put on the floor. Mr. Jones, you and I were here when the last authorization of military force was undertaken. And I can say that during that period of time, there was some of the best debate that I have seen here in the Congress. That needs to be done again. What I'm curious about is knowing, for example, I join your lead on releasing the pages of the intelligence community that were not made available to the public, and I appreciate you for that as well. But what are you being told, if anything, over the course of time when you have asked through these letters? Certainly, you must have had some conversations with the respective speakers and others in leadership. What are you being told as to the why we are not doing this? And let me just add a caveat. I know that the president sent over a proposal, and I don't agree with the particulars in that proposal, and that's why there needs to be a debate, in my view. But if you could answer that question, I would appreciate it.
Judge Hastings, I will tell you that and we have got no response. We didn't get any response from Mr. Boehner to the 5 letters. I talked to him a couple of times, when he's on the floor, and he said, well, we're going to look at it. But I always felt that, quite frankly, I don't want to be too condescending, but I always felt like that too many colleagues would rather for the blood be on the hand of the president than on our hands. Again, it should be on our hands. I don't care if the president's a Democrat or Republican. When our young men and women are over there giving their life, then we all should share in the blood. But we've gotten, I did have a letter today signed by Thomas Massey, myself, Jim McGovern, and Barbara Lee to Speaker Ryan. This will be the 3rd letter we sent him, asking him to please join us in often supporting this kind of debate on the floor of the House.
Thank you very much. And I yield back, Mr. Chairman.
Gentleman yields back his time. Thank you very much. The gentleman from Alabama.
My colleague from the Armed Services Committee, thank you for coming here today. You have been indeed consistent about this in your question. I remember your colloquy with Secretary of Defense. I agree with you. There needs to be at least a debate on an authorization of the use of military force. And I don't think either of the AUMS we have today are sufficient to cover, particularly what we're doing in Syria. So I applaud your motive. I think I've signed at least one of your letters.
You did. Right.
So I join in the effort to try to get to that debate. I think the real question is, with regard to your particular amendment, whether that's the best way to push us to that debate. But that's perhaps something we should save for the floor and have that debate there. But I just want to let you know that I agree with you. We need an AUMF, and if I can do anything to help push that cause further, I'm more than happy to do it, and I yield back.
Thank you very much. Gentleman yields back his time. Does the gentleman from Georgia seek time? Gentleman does not seek time. Mr. Jones, I'm not picking on you because we don't have other members here yet. In fact, I'd like to applaud you that I believe that your service, in particular to one of the most important bases to the United States Marine Corps, provides you with great sense of pride and authorship in many regards. Not only that these young men and young women who come from all over the country to serve their great nation at many risks and with disregard necessarily to their health or safety happens on a daily basis. And I've watched you over the years. What I know is a very difficult emotional task that you take on also. What we're seeing that's just happened over the weekend has deeply struck a number of people, notwithstanding those that live directly in the area and those that are from that state, but from the United States. And I just want you to know that I think every member of this body not only understands your desires, but we applaud you in the leadership that you provide on behalf of so many families in this regard. And I look forward to this committee getting closer and closer and closer to the attributes of being able to answer questions. And I think your amendment today gets us a little bit closer. And I want to thank the gentleman very much for being here.
Well, I thank each one of you for your kind words, and I'm pleased that Mr. McGovern and I have always said it's been very interesting. He's liberal, I'm conservative, but when it comes to war and it comes to the Constitution, it doesn't matter whether you're liberal or conservative. This is an issue for the American military that they deserve to have our support. So thank you all for your comments and look forward to working with you on this.
Yes, sir. Thank you very much. The gentleman can either stay or go as he chooses. We're going to keep on going here. I note and want to note for sure that what we're going to attempt to do is, Robert, we're going to attempt to have you feel free to pull that microphone up. Anything you brought for our awesome stenographer, we'd like you to read and leave for her. The committee is not in its full regalia today, so to speak. As you know, many members, including yourself, were downstairs. We're delighted that you're here, but we want to make sure that you get a chance to approach the committee, and the gentleman's now recognized. If you could please tell us, I'm sorry, which number amendment that you've got.
I'm not in a position to tell you that yet. I just ran up here.
Pittenger, you know which number Pittenger is?
HR.
Yes, sir, it's got an amendment number here. Let me see if I can, 19.
Thank you.
Let's look at that, and thank you very much. If you'll just hold just for a second. 18, yes, it is. I show 19, 20, 21, 22 perhaps. 19 through 20. Well, at least through 21. 20, no, not 20. Looks like 19 and 20 to me. Gentleman's recognized.
Thank you, Mr. Chairman. I do appreciate you taking the time to consider this amendment. As you know, Mr. Chairman, the President has many times made references toward withdrawing funding from North Carolina in punishment for recent legislation relative to the funding of HB2 in the state of North Carolina. The Justice Department, Transportation Department, Education, Housing, and Urban Development Department have all come out with this intent to defund, as well as White House Press Secretary and other advisors of the President have spoken in this regard. So to that end, I would submit to the committee our interest for this amendment is relative to the separation of powers, and that we should not allow the executive branch to exert their authority over North Carolina and bully North Carolina. These threats have a profound effect on our budgeting process, and we do not believe that it's constitutional nor is it fair. The administration is jeopardizing our jobs, our businesses, our vital constituent services, and we'll be the ones that are negatively be affected by what he's challenged us with. So to that purpose, I would ask that the amendment, which is similar to the amendment that we had filed, received 227 votes on the Energy and Water Appropriations Committee, a similar amendment be adopted for this, by the Rules Committee, to be joined with this legislation.
Thank you very much. I am distressed that you had to do this. I find it completely incomprehensible that the President of the United States would intervene in such a matter that is a judicial matter. I believe states are entitled to take their own actions, and I would wish and hope that the President of the United States would not only respect, notwithstanding the 10th Amendment, but also the ability of judicial review in this matter. And I want you to know that while I'm delighted that you brought this to us, I'm worried about the effects of an overzealous White House. I think the thing which I fear most is big government. Big government is the biggest problem that we had, I think, to our freedom. And I'm delighted that you're here and have brought this, and this committee is not only going to look at this, but make a decision, and I want to thank you. Mr. Gibson, Mr. Collins, Mr. Byrne, Mr. Newhouse, Mr. McGovern, Judge Hastings, Do not seek time. Thank you very much, Mr. Penninger. We appreciate you. I'm sorry, Chairman Cole, do you seek time?
Thank you, Mr. Chairman. I
Thank
do
you.
appreciate this time.
Thank you very much. I know we're struggling as we get through here. I would defer to the gentleman from Washington to make an announcement about his favorite mayor who has joined us.
Thank you, Mr. Chairman. I have the privilege and the honor of introducing the mayor of Irving, Texas, who is with us today, and I think her children may be there. Kate and Pierce. Pierce is in the office. Mayor Beth Van Dyne. So we welcome her from Irving. If any of you think you've never been to Irving, I find out if you've flown through Dallas-Fort Worth Airport, you have been to her fair city.
You've been to Irving. You know, Mayor Van Dyne was here last night up at the Rules Committee and had a chance to run into Dan and join him. He said, you know, it's one of my favorite mayors. So I felt like it was only fair for us to introduce Mayor Van Dyne. Mayor Van Dyne, I want to thank you for taking time to be with us today. I also would like to introduce, they don't have to stand, they can just watch, but I've got a bunch of my college interns and some who are going to college, one who's in high school, two who are in high school, and then a couple that are graduate students. First, Hugo Potts from Dallas, Texas, Beacon College, who's a junior. Katie Wallach, who is Mayor Van Dyne's daughter, who is from North Hills Preparatory School. She's a senior. Colby Markham, who is from Dallas, Texas, actually from Plainview, Texas, a graduate student from Southern Methodist University. And Colby is looking to be a United States Marine Corps officer or a naval intelligence officer, and I'm very proud of him. Edward Kenya, who is from Dallas, Texas, graduate student at West Texas A&M. And Madeline Taraz, who is from Southern Cal, USC, Los Angeles, California. She's been in my office and spends a good deal of time trying to keep me straight. And lastly, Joseph Adams, who attended last night from Bethesda, Maryland, Georgetown Prep School, where he's a senior. Okay, we're slowly trickling in members. We had decided that we would be here and make ourselves available. Mr. McGovern, would you wish to take time to speak on your
Sure.
amendment? Gentleman's recognized.
I appreciate, thank you, Mr. Chairman, and I understand that my colleague Walter Jones has already spoken on the amendment, but basically, my amendment, number 64, says that no funds can be obligated or expended for combat operations in Iraq or Syria unless an AUMF has been enacted. It's that simple. It's a simple amendment. If you want the money to carry out combat operations, then Congress needs to do its duty, live up to its constitutional responsibility, and debate and approve an AUMF. You know, I've checked with the parliamentarian, and they're prepared to recommend that this is germane to this bill. It doesn't say that the Armed Services Committee has to draft an AUMF or that the Appropriations Committee has to draft an AUMF. Historically, that has been under the auspices of the Foreign Affairs Committee. All this basically says is we're not going to continue this endlessly unless we do our job. And I sound like kind of Johnny One Note up here in this committee, but I just have a very difficult time, you know, justifying this kind of continuation of these wars on an automatic pilot when we don't even have the guts to debate these wars or vote on them. Now, the time to have done this, and we tried to do this, was before we reengaged in Syria and before we reengaged in Iraq. And I was told at that time, oh, no, we can't do it then. You know, now we're re-involved, and our men and women are in harm's way. And now we're being told, well, we can't do it now because it sends all the wrong signals. I would just simply say that the signal we are sending by not engaging on this issue and not doing our job is that somehow this is, you know, not a priority. And I don't think any of us want to leave that impression. And so, again, I would urge my colleagues just to make it an order. It's germane. Let's have a debate. There should be multi-day debate, but if you only give us 10 minutes, we'll take the 10 minutes. At least that's something. It's better than nothing, but this committee could expand it if it wanted to. But again, I'm proud to join with my colleague, Mr. Jones, Some people on this committee would like to enlarge our military footprint, in these wars. Some of us would like to reel it in. Doesn't matter what you believe. I think whether you're pro more war or want less war, we all ought to agree that the Constitution says we have a responsibility. And that's all this does. And if we're not going to have the guts to do it, then, we should not expect our men and women to be in harm's way. They should be home with their families and not have to be at risk because we don't want to debate this. So it's that simple, and I hope my colleagues will make it in order.
Thank you very much. Does anyone have any questions for the gentleman?
I would just say one thing. If this were an open rule, this would be in order. And so I would just remind my colleagues of that. Thank you.
Yeah, I think the gentleman's correct. I do not know of any points of order against the provisions that are in the bill. This gentleman, Mr. Colston?
I just want to thank my
Jump
friend for
recognized.
bringing forward the amendment. I'm not sure. I want to think through whether I would support it, but his basic point's absolutely right. We ought to be having this debate. We ought to have this vote. We should have had it many months ago. Should have had it before a single American was ever deployed. And this has been an error, I think, on both sides in some senses, because I think the administration has thought it had the power to do whatever it wanted. I don't personally accept that position. I know they hold it in all sincerity, but this is one where the Congress ought to reassert its authority. I think the Constitution is pretty clear about where war-making authority resides, and it's here. And my friend is right. We've avoided debate on both sides, one by saying, well, we have to wait till we're asked, the other by saying, well, we have the right to do it anyway, but we'll ask you. I don't think either side looks very good in this. And I think my friend has been very consistent in his position. He's argued it well, he's argued it eloquently, and, I hope your amendment is made in order.
I want to thank the gentleman because he's been outspoken on this as well. And I hope we can have this debate. And I thank my colleague, Mr. Jones, for his consistency on this issue, too. And I think it's the right thing to do. So I yield back my time.
Yes, sir. I might add that Mr. Jones and I ride the elevator a good bit together, and that he has taken a consistent viewpoint that I needed to not only listen to him, but that he would plan to come back and see this committee often. And I told the gentleman when he was here, notwithstanding that you could not be here at the exact time, that he would speak on behalf of both of you, and I believe you've expressed yourself well, and I want to thank you very much. Okay, I do not see any members that are here. With that said, I note that we are, Mr. Byrne, thank you, Judge Hastings. Mr. Byrne does have an amendment. Now might be a good time. I was going to wait till about 10:30 tonight to ask him, but let's go ahead and do that now. The gentleman from Alabama is recognized.
Yeah, I have amendment number 5, and I think it has a revised version. It was revised from the original form to be precisely the same as a amendment that was offered to the Milcon Appropriations Bill by Mr. Fleming of Louisiana. It's pretty straightforward. It essentially would prohibit any use of funding for housing unaccompanied immigrant minors on military property. Let me tell you why it's come up at this point in time with me. There is a proposal to house these minors on 2 airstrips in my district that are operated by the United States Navy out of Whiting Field, Pensacola Naval Air Station. Let me describe these strips to you. They are in the middle and lower part of Baldwin County, very flat, very low, very wet, great breeding ground for mosquitoes. We are right in the middle of Zika threat right now. There is no structure on either of these 2 airstrips to house anybody. They're simply touch-and-go airstrips, so they don't require any buildings. So there's literally nowhere to put these children. So the best we could do would be to put them in some sort of temporary housing, which in an area like that has no sewage at all. I have questions about whether the water out there is potable. And in the Zika season that we're in right now, not to mention hurricane season, and we're putting children in temporary housing during hurricane season, I found it odd that they would even be considering it. We brought all of these things to the attention of the people at HHS that are doing this, and they have basically deflected everything that we said. they are going forward with at least reviewing these particular places. They are totally unacceptable for children. Whatever you think about this program, you would not put your child on these airstrips. And if the Navy's going to do touch and goes out there, we've got children from other places that don't speak English who could, as children sometimes do, get away, and then something tragic could happen. So I hate to do this. I just soon not do it, to be honest with you. But given the lack of response that we've gotten from the people that are supposed to be in charge of this, I felt compelled to do it. Mr. Miller of Florida, who has the adjoining district in Pensacola, has joined with me in the amendment because it would similarly affect some places in his district. I'm not here to speak for him, but I think he and I share the same concerns. I want to underscore my main concern here is for the well-being of children. And I would not put my children out there, nor would I want to put anybody else's children out there because I believe it would be irresponsible for me to do so. And I'd be happy to answer anybody's questions.
Mr. Byrne, thank you very much. Does any member of the committee have a question for Mr. Byrne? Gentleman's recognized.
You know the area much better than I, and I agree with you in your proposal. My question is, there are other military bases that are underutilized. And would your argument be if immigrant children were placed in those facilities that are underutilized, that that would be a bad thing?
Judge, I struggle with how to write this amendment, and we tried to write it a couple of different ways, and basically, we just wrote it the way we did to comply with the parliamentarian.
Understood.
And there may be some areas like that. I can't answer that because I don't know
Yeah.
every military installation.
I filed a measure about 6 years ago allowing that in disasters in this country, the many ones that we have where people have to be removed from their homes, if we use Katrina as a basis for this argument, the people from Katrina were scattered all over the United States. It would seem to me not unreasonable to, in some of the underutilized military bases, to have people housed there. We paid for them to be housed at Holiday Inns and other facilities, and therefore that's the argument I made. It was interesting because I got a thrust against me saying that I was trying to build camps to put people in America. And it was the farthest thing from my mind. Well, former Senator Bob Graham and I have been working on immigrant children issues for quite some time, particularly the children who come here unaccompanied as minors. But that said, I fully support your amendment because I believe you know your territory better than I. But I do think underutilized bases ought to be used in a better way.
Yes, sir. Thank you.
Any other questions for the gentleman on his amendment? Seeing none. Ms. Lee, welcome. We're delighted that you're here. We're a few minutes away from the vote actually expiring, but we're going to go ahead and allow you to give testimony without objection. The gentleman is recognized. Anything you have right will be in the record.
Thank you very much,
Yes,
Mr.
ma'am.
Chairman. I want to thank you, our ranking member, and all of our members here for the chance to testify on behalf of my amendment. It's Lee 96, and I request that it be made in order under the rule for the defense appropriations bill. This amendment is very straightforward. We've seen it before. It would actually, upon enactment, would prohibit the funding for the 2001 authorization to use military force beginning on April 30th, 2017. And that window, that 3 or 4 months, provides Congress ample opportunity to draft a new AUMF, debated and voted up or down. It's quite clear that a growing bipartisan group of members, scholars, and public need this and want this, and this is what should happen. According to a report that was released last month from the Congressional Research Service, it showed that the current resolution, the current AUMF, 14 years later, it's been used 37 times in 14 countries to wage war with little or no congressional oversight, and that's the declassified version of the report. It's been used 18 times by President Bush and 19 times by President Obama. And this report, again, only looks at the unclassified incidents. Not only has this authorization been used to justify military action thousands of miles away, it's also been used much closer to home to allow warrantless surveillance and wiretaps, indefinite detention practices at Gitmo, targeted killing by drones, including those of American citizens, and it's been cited as the authority for the nearly 2-year-long war against ISIL, a war that, of course, Congress has not debated, we've never voted on it, and we've never authorized it. Our brave servicemen and women, they continue to be deployed around the world. Every day, more and more are deployed, and we're missing in action, Mr. Chairman, when it comes to our constitutional duty. They really do deserve a Congress that has the courage to debate the war that we're asking them to fight. And we all agree, I don't think there's any disagreement, that ISIL must be degraded and dismantled. And so why are we really ducking our job? Every day, more bombs fall, and also the field of combat. Even though we say we don't have combat troops, the field expands. We've spent more than $10 million. We've spent an additional $615,000 an hour. That's what that $10 billion, breaks down to. So it's far past time for the American people to hear the costs and consequences of these actions, and we should debate it on the floor. And I know we don't have a common position on what any new AUMF might look like, but many of us agree that the overly broad, almost 15-year-old AUMF represents a major and very concerning deterioration of congressional oversight. That's why then I could not vote for it. If it came up again with the broad powers that it gave the authorities to the president, I would vote against it again. So this amendment is especially important right now. It does give Congress plenty of time to authorize debate and formulate a new authorization. Finally, in closing, I hope that the committee makes an order. I don't know if you've talked about the McGovern-Jones-Lee amendment, which would prohibit funding for combat operations in Iraq and in Syria until, again, a specific AUMF has been authorized for such operation. So I want to commend my colleagues for their unwavering commitment to ensuring Congress does its job, debates, and votes on the ongoing war against ISIL. And this has bipartisan support. It's growing, and we need to stop being missing in action and stop ducking our job and come forward and do the right thing on behalf of our national security and on behalf of our troops. Thank you.
Ms. Lee, thank you very much. Mr. McGovern, do you have any questions?
I would just want to say, I want to thank the gentlelady for, again, being steadfast on this issue, and she's right. And, I mean, the idea that we are justifying these current wars on AUMFs that were passed in 2001 and 2002 is ludicrous. I mean, you know, again, we ought to do the right thing, and that is null and void the old ones and pass a new one. And that's what I hope we'll have a chance to debate and vote. But I thank the gentlelady. I support her amendment.
Thank you very much. Mr. Polis? Thank you very much. Does any other member seek time?
Just
for
quickly,
questions? Gentleman's
I
member.
want to join my friend thanking the gentlelady. She's been perfectly consistent on this question, I think perfectly correct. This is really a question of Congress doing its job. We haven't done it, and I think the gentlelady's amendment should be made in order. I hope it is.
Thank you very much.
Thank you very much. Ms. Lee, thank you very much.
Thank you.
I would like to, without objection, add a statement from the gentleman from Colorado, Congressman Ken Buck, that be placed in the record, and we'll do that. Mr. Polis, I don't know if you saw where one of your favorite mayors was back here, Mayor Beth Van Dyne from Irving, Texas.
Wanted to welcome a good friend. We go way back, the mayor of Irving, Texas, Beth Van Dyne. Welcome to our great committee. Thank you.
Thank you very much. Okay, what we're going to do now is we're going to be in subject to the call of the chair. We're going to come back as soon as the last vote, and I suppose we'll have a full house immediately thereafter. So we will be subject to the call of the chair. Rules Committee will come to order, and thank you very much. It's pretty obvious to me that a bunch of members have figured out we're going to make their amendments in order, and so most of them have decided not to come. I'm delighted, however, to welcome the gentleman, Mr. Sanford, and gentleman, Mr. Gibson, and I'd like to have both of them please come to the table. And I'm delighted that you're here. Mark, you not only provide us a lot of business, but about a lot of intellectual content. We're delighted that you're here, and the gentleman's recognized.
I thank the gentleman. I won't rehash the nature of my amendment. It's very similar to the last amendment I had on this front. I think the question for this committee is whether or not it's germane. I think it is. And I guess I'd leave it open at that in the interest of time, since everybody's busy, and would defer to my colleague. Unless there are questions, which I guess we'll come back to.
So the gentleman's through with his testimony?
I'm sorry?
Is that your testimony and your amendment?
It is.
Good. Okay, thank you very much. Mr. Gibson, we're delighted that you're here. I know that the gentleman has a amendment evidently number 40.
I think it's 39,
Oh,
Chairman.
I was
but-
told 40. If it's 39, I'll go to 39.
Yeah.
And the committee will be allowed to get their 38.
It's 4Z. I'm being corrected by your able staff.
It is number 40.
I stand corrected.
The gentleman's
40.
recognized.
Thank you, Mr. Chairman. Good to be back with the Rules Committee. I take nothing for granted. I really know I have to come and I got to make my case. And, you know, this amendment, very simple. We're moving $1 million out of one account. This is the account that funded the Aerostat, sometimes known as BLIMP. But basically, it's a reconnaissance platform. We had an incident here not that long ago where one of them got loose from Aberdeen and ended up causing a significant amount of damage, making its way to Pennsylvania. Our committee, I sit on the Armed Services Committee, we significantly reduced this account because we think the program's got some issues and we're looking for some leadership and rearrangement there. The HACD also took money from this account, but left more than the authorizing committee. My amendment moves $1 million from that account to an account that supports our extended range cannon artillery. Mr. Chairman, this is, yes, $1 million is not a lot of money, but this is, I think, a very important issue that we should focus on. A big believer in peace through strength, and, you know, the deterrence that comes from having a very strong military, allowing us to lead with our strengths, our ideas as instantiated in our founding documents, our highest ideals that I think on our best day that really reflects well in the world, leading with diplomacy, commerce, and trade. But we have issues right now with regard to our indirect fires, artillery. We are falling behind. And in part, it's somewhat understandable. We've been involved in conflict now for an extended amount of time that has been largely counterinsurgency focused and to some extent humanitarian in other parts of the world, and some would describe it as nation building, but it has not been the full engagement of the combined arms fight. And while this has been going on, our competitors have continued to march forward and with their capabilities. So I have been watching very carefully and closely actions in Ukraine and in Syria. Russia is demonstrating an ability to mass fires with an extended range. Our assets, pairwise with their assets, are best, and we have some impressive precision-guided munitions, to be sure, including the Excalibur, but their range is up to a third longer than ours, and they have the ability to mass, and as Mao Zedong said, you know, quantity has a quality all to its own. I'm concerned about this. I think the committee has done some good work. They've moved $20 million into this account. I think we could probably double that, but what we've done in this amendment is we've moved $1 million so that we can bring more attention to this to our colleagues on the floor, and we also think that that additional money will be helpful. So, you know, with that said, Mr. Chairman, I'm ready to take any questions that you have on that.
Thank you very much. Ms. Jackson Lee, welcome to the Rules Committee. We're delighted that you're here. If you'd please let us know, I think you have 4 amendments, if
Yes.
that's correct.
Yes.
If the gentlewoman could please focus us on those 4, those number. Do you know what they are? If not, I will ask our crack staff.
I will quickly get to them. Looks like they're in different orders, but let me, Thank you very much, members of the committee. I've offered 4 amendments, and might I say, I may have another one. I'll speak briefly about it, but in any event, let me...
Gentlemen, hold just a moment, please. I know you've got 105, 89, 83, 88, and 82. So I'll go back over those in the reverse order: 82, 88, 83, 89, 105. If the gentlewoman will tell me which one she would choose to discuss or the issues, I'll tell the committee which number that is.
I'm starting with 82,
Number 82.
and I'm going to go through the rest of them.
Yes, ma'am. Gentlewoman is.
Not necessarily in order, but
Good.
thank you so very much. This is work that would, number 82, would increase funding for military personnel, Navy by $2 million and reduce the amount made available by another $2 million. The amendment encourages the Secretary of Defense to allocate resources needed to provide technical assistance by U.S. military women to military women in other countries combating violence as a weapon of war, terrorism, human trafficking, narcotics trafficking, and their impact on women and girls across the globe. So it is a peace amendment that would encourage women military to address the question of violence against women in those respective countries. It is a task that we often do in doing exchange with other military, and I would encourage my colleagues to support that amendment. This amendment would provide the Secretary of Defense flexibility to allocate resources needed to provide technical assistance for that particular effort. Amendment number 88 is an amendment that emphasizes research, medical research related to breast cancer, and it is an amendment that I've offered before. It is still needed, and that is triple-negative breast cancer. There is a large fund dealing with research on cancer under the defense bill. This is to highlight an often forgotten aspect of breast cancer. Triple-negative is a term used to describe breast cancers whose cells do not have estrogen receptors and progesterone receptors and do not have an excess of HER2 protein on their cell membrane of tumor cells. Between 10 to 17% of female breast cancer patients have triple negative. This is obviously something that can impact the increasing number of women in the United States military, 3 times more likely to cause death than most common forms of breast cancer. 70% of women with metastatic triple-negative breast cancer do not live more than 5 years after being diagnosed. And so I would encourage the support of those amendments as well. And then I would encourage the support, if I can. Amendment number 89 makes clear that nothing in the bill contravenes the President's authority under Article 2, Section 2, to take actions he has determined to be in furtherance of U.S. national security and foreign policy interests, including the deployment of armed forces personnel to assist efforts to locate and support the safe return of over 200 girls who are reported to have been kidnapped in Nigeria. I would correct that and say have been kidnapped in Nigeria. And we have been working on this with a number of colleagues. We know that the African Command has provided technical assistance. This is to reemphasize the horrors of Boko Haram that's now spread their ugly terrorism even beyond Nigeria to Chad, Niger, Cameroon, and to insist on bringing all of those girls back. The PTSD amendment is one that is number 83, and I'll just make a simple statement about that. Texas has one of the highest numbers of returning soldiers from Iraq and Afghanistan. This particular amendment provides additional monies for research and deals with homeless individuals. In the past 4 weeks, my constituency has dealt with a former Marine who stabbed to death an 11-year-old child walking home in broad daylight from a middle school who was at the school late because of a science project and walking home by himself. He was stabbed repeatedly and died on a street in Houston. It is now alleged that this individual, unfortunately, who was in a homeless shelter, was suffering from some form of PTSD. We obviously don't have all the facts, but we are determining these issues are confronting our men and women who are returning from the battlefield. And I know that there is support for PTSD treatment, but I've offered this amendment in the past. I work with former Chairperson Murtha, the late Chairperson Murtha, Colonel Murtha, and we established a PTSD center in my district. I'm now trying to continue those treatment dollars going to other entities to ensure that there is sufficient PTSD treatment. I think I have an amendment dealing with that, and that is amendment number 83. I think the 105 may be the amendment dealing with an increase to that number. But the amendment number 83 will stand on its own. And with that, I yield back and welcome questions.
Thank you. Thank you very much. Judge Hastings.
Chairman, I support all of the amendments of our presenters and thank them. I'm a co-sponsor of Mr. Sanford's amendment, and I heard him say that if there's that there may be a question about germaneness, and if that is the case, then I would most respectfully ask that we give a waiver so that that amendment could be made in order. And I'm not sure that it is not germane. Thank you, Mr. Chairman.
Yes, sir. Sitting members seek time. Gentleman from Louisville, Texas, Dr. Burgess.
Thank you, Mr. Chairman. And Mr. Gibson, can I just ask you, this affects the border down in Texas? The aerostats that were in Helmand Province in Afghanistan have now been transferred to the lower Rio Grande Valley sector. What does it cost to keep one of those aerostats up in the air? Is there a monthly or yearly cost that's associated with that?
I would want to submit that for the record. Clearly there is a cost associated with daily PMCS, and then there's a weekly and a quarterly check. There's certainly a cost associated with the personnel that are responsible for maintaining that, but as to the exact dollar, I'd want to check on that.
Very well. I've just observed, Mr. Chairman, I think you took a CODEL to that area. We did observe those observation posts, and they seem quite effective, but they may also be terribly expensive. So I think that's fair information for us to have.
Well, I will also say that, I've used that resource as well extensively in Iraq. So I see the utility of it. I'd also tell you that, there's a pretty broad consensus among the committees of jurisdiction that the program needs a good looking at. So the question is how much. I mean, quite frankly, the Senate Appropriations Committee zeroed it out. Like I said, House Armed Services took a deeper cut than the HAC-D. So somewhere we're going to meet on this and figure out what the goals are going to be with the money that they have. But I think that given the state of play among all the committees of jurisdiction, that $1 million to fund what I think is very important investments so that we can begin to catch up with the Russians and the Chinese when it comes to our indirect fires capability is, I think, it's really important to do.
Thank you, Mr. Chairman. I'll yield back.
Back to time. Sitting other members seek time.
Mr. Chairman?
Gentleman of Georgia recognized.
Thank you, Mr. Chairman. I apologize for missing this testimony, but Mr. Sanford, I wanted to ask you about your amendment. I love serving on this committee because I learn so much because smart people come up here and tell us smart things. I don't believe of the thousands of amendments I've ever looked at, I've ever seen one that said, you know what, I don't know what the law might be in the future, but just in case I want to preserve the state of play right now. Is that what the amendment's going to do? It's going to say, it says, irrespective of what this body might decide tomorrow, irrespective of how the law might change next month, with respect to the one provision you're interested in, we're not going to let the law change for this fiscal year, even if Congress acts tomorrow, even if the president signs it tomorrow?
Excuse me. I think the reality is we don't know. We have something in flux. In other words, so this committee ruled out of order my amendment to the National Defense Authorization Bill, saying it was not germane. We don't know exactly how that movie ends up, given the fact that John McCain, for instance, head of the Defense Committee over on the Senate side, is where I am on this particular amendment. So in the sausage-making process, it is a political process, I don't know exactly where it ends up. The administration is against the provision. The Department of Defense is against the provision. John McCain is against the provision. I'm against the provision. But I don't know what comes next. And so all I'm saying is I think it's relevant at this point in an appropriations bill to say this is just a strike amendment, to say we don't know what's going to happen in terms of the future in the resolution of those different issues with those different constituencies. But what we do know is it's in there right now, and therefore why don't we strike it?
But this would preclude any changes to that section. It would, if, however one would define it, if one wanted to make that law better from your perspective, make that provision better from your perspective, voting for this amendment would prevent us from making any changes, period.
Well, again,
it's going to solidify the status quo for.
No, well, what I'd say in deference to my colleague from Georgia who has superior mental capability to myself across the Savannah River, is what would you suggest in terms of modifying the language so that we might be able to skin the cat that I'm obviously after?
Well, my thought is ordinarily we're here on no funds shall be used. Something's gone wrong in the administration. Something goes wrong in the lawmaking process. We recognize that it has gone wrong. And the only tool we have in our constitutional arsenal then is the power of the purse, and so we try to make that change. And in this case, we're not even giving ourselves the benefit of the doubt. We're saying, despite the long list of incredibly powerful members of Congress that you listed, despite the support of the president that you listed, just in case this doesn't go the way that folks want it to go and through the deliberative process, we want a backup plan to say no funds shall be used. And for me, it's not an issue on the policy. It's an issue on the practice. What is that practice of saying prospectively to Congress, even if you change the law tomorrow, we're going to have put language in place today that anticipates ignoring the law that Congress deliberates on and the president signs tomorrow. And something about that makes me uncomfortable. I've never seen that before.
Absolutely. And I would simply say this. I do have, may I defer to staff on this question as to why they crafted it in that particular way? Why? Just, I think we're informal enough. Could you yell real fast?
No, sir. He may come and whisper in your ear.
We are in this unfortunate circumstance, as we have found ourselves in, sadly, too often, where NDAA does not get passed until after the appropriations bill gets passed. So this is our House tool to use. I cannot recall having seen us, again, prospectively prohibit the collective wisdom of the House and Senate and the White House from applying. And I don't know if the subject of tennis shoes is the place that it rises to such a great magnitude that this is where we would exercise that.
Would the gentleman yield?
Be happy to yield.
I would say two things. One, this amendment is not about tennis shoes. The only reason I've come back for a second bite at the apple is if you were to talk to our colleague Brad, who's the only podiatrist in the U.S. Congress, he believes passionately that you'll see more injuries with more recruits if it goes through. And we spent about $100 million on related incidents within DOD training cycles each year. And so we're talking about a cost to the taxpayer, and we're talking about real impact to the recruit. 13 is better than 1. We've talked before, Mr. Chairman. You were a distance runner. Having more choices available to the new recruit because different feet need different things. And what the DOD has recognized to date is, given the diversity of different feet that are out there, the last thing we want to do is put a new recruit into a brand new pair of shoes that may not work for them. And so this is not about tennis shoes. It's about what might be best for the recruit and what might be best for the taxpayer. And so I have here language from the parliamentarian. I have a direct email, which I'll submit to the record, saying we have been unable to identify any problems with your latest draft. That was a word from the parliamentarian. We're just trying to skin the cat. It may not be the most delicate way or the best way of doing so. We were just driven by the parliamentarian that this would be acceptable language, which is why we offered it as we did. We'd be glad to amend in whatever form might be best for this committee.
I know that the gentleman brings this amendment sincerely. In fact, I think you were one of the most thoughtful members in this body. And I enjoy talking with you about all the things that we have a chance to talk about. I generally end up learning something new and seeing it from a different perspective. Too often these days, however, I find myself thinking that my colleagues are losing faith in the collective wisdom of this institution. Too often I find folks, well, as we are in closing down the appropriations process. Folks are afraid that we won't be able to police ourselves with good amendments, and so we need to protect ourselves from our own collective wisdom. I just think so much more of us collectively than that, and looking down the road and saying, if Congress changes its mind, if the president signs a new bill into law, we are prospectively saying that that law will be of no consequence whatsoever. Seems emotionally troubling,
Right.
even if parliamentarily practical.
Would the gentleman yield on
Be
that
happy.
point? As we both know, no Congress can bind another Congress. So in fact, there is no 10, 15, 5-year pattern as to what might come next. If we want to change it in the next Congress, we can change it. We want to change the next session of Congress, we can change it. We cannot bind ourselves into the future. That's the reality of the congressional experiment. Again, what they were doing was they were based on a June 9th day, wherein, based on the tea leaves that had been laid out with NDAA, they're reacting to that and trying to draft something that would, again, allow choice for recruits. It may be the imperfect way of doing it, but it was the way that the parliamentarians suggested we do so.
The gentleman makes an interesting point. If one were to win on the substance of this amendment, one would presumptively win on the substance of the next series of bills and amendments as well. And if the body were to change its mind on the gentleman's amendment, they would simply repeal it in NDA come next month. I again love this committee, Mr. Chairman, because I always learn something new. I'm putting this on the list of new things that I've seen here today. Yield back.
Thank you very much. Ms. Slaughter, do you seek time?
I do not. Thank you
Do
very
not.
much.
I'll yield myself my time because I gave it up earlier. Mr. Gibson, I'm a strong advocate of Aerostats. I fought long and hard to get them not only on our borders, but really to aid our men and women in protecting this, what I believe is protecting this nation. The gentleman, Dr. Burgess, and I have witnessed a number of times firsthand about their effectiveness and how they're used. The example that you brought up was of the Northeast, and it did highlight that we had an aerostat in the Northeast. What do they use that aerostat for in the Northeast?
Well, Aberdeen, of course, is a place where we also, we experiment, we
True.
test. In terms of any operational employment of it, I would not want to comment on that because it may very well be that is classified. But I do know that Aberdeen is widely used to test. Now, might I add that, when I was in Iraq, we would use the aerostat for point protection. They're
pretty good.
Oh, yeah. I mean, for a forward operating base, you get a very good look. It's got it's a stable platform. It's got good optics, recording capability. It's very impressive.
And you can shoot it with a 50 cal unless you stay after it. You can't take it down. Is this true?
Yeah.
Now, how much then, and perhaps I have just one more question.
Yeah.
How much is the overall budget? If you're taking $1 million out, what is the account total?
So we're leaving, in the HAC-D, we're leaving $11 million for the program as it consolidates. As I mentioned, the NDAA leaves $2 million. The Senate appropriations in their mark, I understand, is going to take it to zero. So there's going to be in the state of play, there's going to be a compromise here somewhere. I feel pretty confident that this move here to help us with the capabilities for indirect fires, which I think we really need to put more focus on, that this pay for is going to be within that state of play, ultimately what we decide.
Good. Thank you very much. Does any other member seek time with our guests? Thank you. I want to thank this panel of, yes, ma'am.
May I, just for the members, clarify that the amendments that I'm putting forward is the amendment dealing with military peace opportunities for military-to-military personnel, which would be women in the military working with women in military from other countries to promote peace and to promote opposition to violence against women and girls, which occurs around the globe. and that's number 80. That's, just want to make sure I have the right one. Not numbered. Number 83, so that would be number 82. That's number 82. The number 83 would be the PTSD, and number 88 would be breast cancer, and number 89 would be the language that would reinforce our commitment dealing with Boko Haram and the girls that have been taken, and the utilization of any of our resources only under and pursuant to the Constitution. It is an opportunity to reinforce the importance of finding these girls and the horror and terrors of Boko Haram. 105 is presently not to be submitted at this time.
Yes, ma'am. Thank you very much. Mr. Sanford?
One final point of clarification based on my colleague from Georgia's concerns. It was just handed to me that Section 8099 of the bill references the NDA in the exact same way that this amendment does. Section 8099 is the prohibition on the President's ability to move detainees from Guantanamo Bay to the domestic United States. And there's the exact same reference point to the NDA in that case, our prohibition on moving detainees from Guantanamo Bay, as there is in this particular New Balance provision.
Thank you very much. Ms. Jackson Lee, I need to ask one question. The staff inquired to me. Are you asking to have amendment number 105 withdrawn? Or could the gentlewoman clarify her comments to me?
Thank you. I'm asking unanimous consent to withdraw amendment number.
Without objection, that'll be done. Thank you very much. The gentlewoman has now asked that amendment number 105 be withdrawn, and I have responded to that request. I want to thank all three of you for taking time to be here, for your attention to detail, and most importantly, for coming to represent your constituents. Thank you very much.
Thank you.
Yes, ma'am. We'll now pull up the next panel. The gentlewoman from Hawaii, Ms. Gabbard, the gentleman from Arizona, Mr. Gozar, and the gentleman from New York, Mr. Maloney. I want to welcome all three of you, not only to the Rules Committee, but your opportunity to come up and be with your colleagues, to spend some great time with the Rules Committee team that very much works well together, and we try and welcome you, hear your ideas and thoughts, and we're delighted that you're without objection. Anything having read will be entered the record. And the gentleman from Arizona is now recognized.
Thank you, Mr. Chairman. In September of 2014, on the same day Attorney General Eric Holder resigned, the Obama administration took executive action and issued a memo that allowed DACA aliens to begin enlisting in the military. Specifically, President Obama's administration unilaterally expanded the eligibility of the military accessions vital to the national interest, or MAVNI program, to include DACA aliens through a September 25, 2014 memo. Prior to this memo, the executive branch never attempted to enlist DACA aliens through MAVNI. Further, military enlistment rules explicitly prohibit illegal aliens from enlisting in the armed forces. MAVNI is a military program intended for lawful immigrants and lawful non-immigrants. The Department of Homeland Security's website states that DACA aliens lack lawful status and are subject to all legal restrictions and prohibitions on individuals in unlawful status. In a response to an inquiry from my office, DOD confirmed media reports that the Obama administration is accelerating the recruitment of DACA aliens into the military, stating, and I quote, "As of the 30th of April, 136 DACA recipients had shipped to Army basic training in fiscal year 2016, end of quote. When I offered a similar amendment just less than a month ago, DOD reported that only 5 DACA aliens had enlisted in the armed services. Today, DOD confirmed that 141 total DACA aliens had enlisted in the military through April 30th, 2016 as a result of Obama's backdoor amnesty program. According to a previous DOD memo, and I quote, MAVNI was a 1-year pilot initially approved in 2008 by the department. The initial pilot program ran through December 31st, 2009 and had a cap of 1,000 total recruits for all services. The program was reinstated on May 16, 2012 with a cap of 1,500 accessions per year for all services, end of quote. The administration unilaterally increased the cap for MAVNI to 3,000 individuals in 2015 and 5,200 individuals in FY16. As noted by the Nonpartisan Congressional Research Service, the MAVNI program allows citizenship to be granted to any enlistee that serves at least 1 day of wartime service. MAVNI was never intended to be utilized for the benefit of illegal aliens. Testimony from DoD states that MAVNI was created to recruit legal non-citizens with critical foreign language and cultural skills. Retired Lieutenant Colonel Margaret Stock, who created and implemented the MAVNI program, agrees, claiming, and I quote, "The addition of the DACA applicants will force a total overhaul, as original screening systems were created to weed out exactly the applicants who are not now to be part of this pool. It was set up for people who are legally in the country and have been legal their whole history. We have to go back and redo all the security screenings, train recruiters all over again. It's one of the things where people want magic to happen, and bureaucracy doesn't work that way. It's a major bureaucratic screw-up by the Obama administration. The MAVNI program is not designed for DACA at all. It was rather alarming to see DACA being put into MAVNI. Someone didn't know what they were doing," end of quote. Stock is an unbiased source. As a one time, she testified in support of provisions in an earlier version of the DREAM Act. Article 1, Section 8 of the Constitution gives Congress clear jurisdiction on immigration matters. Congress has consistently rejected and failed to act on policies that aim to allow illegal aliens to serve in the military. In fact, the House has rejected DACA 3 times. Furthermore, MAVNI is a pilot program created by executive orders that have never been authorized by Congress. And I'll be looking forward to everybody's comments.
Thank you very much, Mr. Gosar. Ms. Gabbard, we're delighted that you're here. Gentlewoman served our United States military in the United States Army. We're very proud of not only your service to the men and women, but also this grateful nation. We're delighted that you're here as a member from Hawaii. The gentlewoman was recognized.
Thank you very much,
Yes,
Mr. Chairman. I'd first like to speak on Amendment 65. This is with regard to the North Korean missile threat that we have facing both my home state of Hawaii and our homeland. Just a few years ago, officials from the DoD argued that North Korea was many years away from developing missiles capable of reaching our shores. They had developed intercontinental ballistic missiles but hadn't tested them. Now our Missile Defense Agency is reporting North Korea has ICBMs with a range of more than 3,000 kilometers. They've developed mobile road missile systems, which would make it significantly more difficult for our pilots to rapidly target and destroy, or even to detect and have notice before these missiles are launched. What to speak of the fact that recently senior administration officials have acknowledged North Korea has successfully miniaturized their nuclear weapon system so that they can be placed on warheads. Time is of the essence here. We've got to make sure that we are maintaining our missile defense system ahead of the capabilities that North Korea is rapidly developing. Secretary Carter came before the House Armed Services Committee earlier this year where he agreed that we need to improve our missile defense in the Asia Pacific. We need to improve our ability to see these missiles. We need additional radars. And this amendment takes one step in that direction. I've worked with our Armed Services Committee colleagues and staff. We were able to include a requirement in this year's NDAA for the Missile Defense Agency to take initial steps towards putting a medium-range discrimination radar in the Asia Pacific. This amendment provides some of the funding that MDA needs to execute that requirement. MDA leadership is aligned also with this need, as are my colleagues, including Chairman Mike Rogers of the Strategic Forces Subcommittee. I urge the committee to make this amendment in order. This is a mere $5 million that takes one step towards moving us in the right direction to address an urgent threat. I have 2 additional amendments I'd like to provide brief testimony on, numbers 59 and 60. They essentially do the same thing. Amendment 59, as I came before this committee a few weeks ago to testify on the Syria Train and Equip mission. Amendment 59 simply does what the Department of Defense says it's already doing, which is limits DoD funding, prohibits DoD funding from going towards any individuals or forces who are seeking to overthrow the Syrian government of Assad. Amendment 60 is a broader language. It's actually the exact same language that I offered the last time I came here before this committee. As you know, Mr. Chairman, we're fighting two wars in Syria. The war to overthrow the Syrian government, which I believe we must end because it's counterproductive to the second war against ISIS and Al-Qaeda and other jihadists. We should not be providing continued funds towards a program that has shown repeatedly to have failed. There are multiple examples, which I spoke about the last time I'm here. I won't repeat them. The concerning part of the new version of this program, which this bill funds, is that not only do we have an insufficient vetting process, but the current program says that we will vet only commanders of these so-called moderate Syrian forces. Once the commander's vetted, then we'll arm their whole brigade without any vetting or checking process at all. I feel strongly that we need to put an end to this failed program. Amendment 59 would limit the funds to go towards those ground forces like the Kurds and some of the Syrian Arab tribal leaders who've proven to be effective against ISIS on the ground, and it would stop further funding for those who are seeking to overthrow the Syrian government. Thank you, Mr. Chairman.
Yes, ma'am. Thank you very much. We appreciate not only your time, but your involvement and your thinking. I appreciate it very much. Mr. Maloney, welcome. We're delighted that you're here at the Rules Committee. Gentleman's recognized.
Thank you very much, Mr. Chairman. Mr. Chairman, not 48 hours ago, a terrorist gunned down 49 LGBT Americans and their friends and allies while they were simply having fun at a nightclub in Orlando, Florida, a place where they should have felt safe and free. We've all prayed for the victims and their families and talked about ways to stop these events from happening, whether it's defeating radical Islamic terrorism or combating gun violence. And we can and should mourn these 49 innocent lives as Americans, and they were, but we should also recognize that they were targeted during Pride Month because of who they were and who they loved. I've said from the beginning that we should take our example from the brave parishioners in Charleston, South Carolina, who responded in the immediate aftermath to that horrific shooting by coming together in unity with greater love and dignity. They also responded by acting and by recognizing that symbols and language matter, and across party lines, in a bipartisan fashion, South Carolinians banded together to rid themselves of symbols of hate. Because hate has no place in our flags, in our workplace, or in our country, and it should have no place in federal law. Right now, many of the survivors of this horrific attack in Orlando could go to work today and be fired simply because of who they are. In a majority of American states, I believe 28 states, it is absolutely legal to fire someone because of a perception or the reality of their sexual orientation or gender identity. My amendment, therefore, is simple. It says that no Defense Department dollars should go to federal contractors who contravene President Obama's 2014 executive order, which extended basic workplace protections to LGBT Americans. This is about basic civil rights. We had this debate on the House floor a couple of weeks ago, and we showed that a majority of the House agree that we should not discriminate against LGBT Americans in the workplace, and we should not use taxpayer dollars for federal contractors who discriminate. All Americans were created equal, and it is our job to create a more perfect union. My amendment is germane to the bill in that it specifically speaks to the use of the dollars being appropriated. And whether we stand in favor of this non-discrimination approach or against it, there should be no question about its germaneness to this bill. So it is not, of course, whether you agree with the amendment or not. We can and should debate that, but I hope you'll agree that it's germane to the matter before the committee. Thank you, Mr. Chairman.
Yes, sir. Thank you very much. Does any member seek time? Judge Hastings? Yes, please. Gentleman's recognized.
Mr. Chairman, I support all of the amendments being made in order, and I would, as you often say to our witnesses, Mr. Chairman, offer that they leave anything that they have in writing, and I specified Mr. Gosar in this case because he went pretty fast, and it would help our reporter if you left your remarks in writing.
That's a really good point. We many times have difficulty hearing in the room, and it does help us and our stenographers. They're young women who have great ears, but on this side, we don't always, so it helps us out. Thank you very much. Mr. Polis.
I just wanted to especially urge the committee to make in order Mr. Maloney's amendment. I think clearly the terrorists have targeted the LGBT community, and I think we as a country have the opportunity to show that we're better than that we in our country don't discriminate, that we value the contributions of people based on their merits in contracting and every other realm. And I strongly encourage the committee to make this amendment in order. Similar amendments have passed, as you know, on the floor, both in the form of the Scott Peters amendment last year and Mr. Maloney's amendment on another appropriations bill. So I know a majority of the body supports this concept in regular order. The House should be able to work its will. And frankly, I'm proud to say that the House has chosen to work its will in a way that is consistent with protecting gay and lesbian Americans from discrimination. What a wonderful thing that we have a pro-equality majority in the House. And I hope that the minority who wants to oppose those measures certainly has the ability to vote to oppose them as well. But I'm confident that if we do make an order, Mr. Maloney's amendment, it will pass as it has in the past. And it should be the law to show that we as a country are better than this and that we believe that people should be evaluated based on their contributions and on merit. And I yield back.
Thank you very much. Does any Republican seek time? Gentleman from Georgia.
Thank you. I appreciate what from Colorado had to say, though, to be fair, we don't have a majority on these issues because we have yet to send a bill to the United States Senate. That's what it takes to send a bill to the Senate. It takes a majority. And my question for each of the witnesses would be, if your amendments are made in order, and if the House passes your amendments on the floor, would you intend to support the underlying bill and encourage others to do so as well? I'd ask the gentlelady from Hawaii.
Thank you for the question. Yes, if my amendments were passed, it would prove the bill to be worthy, and I would vote for the underlying or the overall bill.
I thank the gentlelady. Gentleman from Arizona.
If my amendment was made in order and passed, yes, I would.
All right. Mr. Maloney?
Yes, I'd be prepared to support the underlying bill, provided that there was not discrimination written in somewhere else, sir.
Fair enough. Fair enough. I thank each of the witnesses. Mr. Chairman, I thank you for the time.
Yes, sir. I do not see where any other member is seeking time. I want to thank all three of you for not only taking your afternoon to be here, but in particular for your thoughtful ideas. And I know, Mr. Gosar, evidently your amendment is, as I understand, still being worked for germaneness, and your staff member who's behind you, in fact, is identifying that as a positive sign. So we'll see what happens there. I want to thank you very much. Yeah. Yeah. The committee is available for any member who would wish to come and present their testimony. We have been available since 3:30 this afternoon and have made ourselves available to members to come here with the knowledge that we had a classified briefing. The chairman does not see where we are being asked by any other member at this time.
Mr. Chairman.
Yes, sir.
And just in light of the fact, and I know there are a lot of different things going on today, and that is including the briefing, but also the outside entertainment being offered downtown at the White House and other things. But I do want to just make a statement, and we've talked about this before. You had made a statement earlier about most feel that they're going to have their amendments already taken care of. I still think it's a valuable asset for members to come, even with of lots of events going on, because it does help, and there is a great deal. I'm not for, I don't think at this point, requiring that, but I do think it is good that they would come, whether they're made in order or not. And I think that just shows a commitment to the process, and just would like to be on record as saying that. I yield back.
Thank you very much. As a matter of fact, when members ask, I do encourage them, as you have suggested, to not only talk with members of the Rules Committee, but also to make their best wishes known. So I think the gentleman was absolutely correct when he noted that there is another activity taking members' time that is off campus, and so that has been a contributory issue about getting people here, and that's why I wanted to make sure we were aware, open for business, and the members could do
Mr.
that.
Chairman.
Judge Hastings.
Yeah, Mr. Chairman, before I get into this, can you give us an idea of what we're going to do schedule-wise at this point?
Yes, sir. Here's what I would say to you. We've gotten some people that I think we thought we were having discussions with that we didn't. We're going to get with them on some issues. I would anticipate that we're not going to go on for forever tonight. We're going to go ahead and recess, subject to the call. We're going to allow people to do things as they choose off campus and get those things done, and then would come back.
All right. Well,
early.
Is the hearing not closed?
Not yet. Not yet. We're getting ready to do that.
Okay.
Well,
I know you do. And this is my point. Then people can go
Well, I don't want
do
to,
their dinner hour things.
I don't want to belabor things, Mr. Chairman, but my friend, Mr. Woodall, and previously, my friend, Mr. Collins, and maybe several others at times when I was not here, have begun what I think is a pattern, and that is to ask witness presenters whether or not they're going to, if their amendment is adopted, support the bill. Well, if a member sees a problem, they can propose a fix or an improvement, even if they oppose the bill as a whole. And I would suggest anyone looking for someone to criticize for breaking this new made-up rule you keep talking about should look in the mirror. There were 13 Republicans whose amendments to the Energy and Water Appropriations Bill passed, but who voted against the bill anyway. One of them was a member of this committee. Another was just here, Mr. Gosar, had all 5 of his amendments agreed to and still voted no on the bill.
Yes, sir.
There were only 2 Republicans who followed this rule you came up with, whose amendments passed and who voted for energy and water on final passage. But again, the idea, if you get an amendment passed, you have a duty to support the entire bill. In my 22 years here, I could only classify that as preposterous with the things that I've seen. That's like saying you ask a car dealer for a red car, and I did once, and when he shows up with a red car that has no tires, you have a duty to buy the car anyway because he gave you the color you asked for. I did get something like red, but it had tires. And remember, the energy and water bill was a Republican-written bill. You decided what was in it in the first place. 130 Republicans voted against the bill, and only 106 voted for it. Republicans are the ones who killed their own bill, not Democrats. If the final product is a bad bill, then members have a duty to vote no. But they should still do all they can throughout the process to try to improve the measure. And I wish, Mr. Chairman, that you would relent on this rule because, or putting members in that posture when they come up here of asking them if their amendment is made in order, or are they going to support the bill?
Would gentlemen yield?
Yes.
Mr. Chairman, I find it very offensive, and I'm not sure that the Rules Committee or any other committee in this Congress has ever in its history said to members who are discussing, are you going to vote for the bill because that determines what we're going to do here. It is totally unfair on the face of it, and I think it's unjudicial, certainly unlegislative theory of anybody's idea that you would pinpoint. There's a quid pro quo in there, you understand?
Yes, ma'am.
That I think is totally inappropriate for any committee in the House of Representatives.
Yes, ma'am. I thank the gentleman and gentlewoman for this. I have only been up here a few years and have never asked a question like that. In fact, one of our members did tonight. I did not have any prior knowledge nor instruct them. I will allow them to take feedback and to reevaluate. As we sometimes do up here, we do things and sometimes maybe a little bit later we think again, and I'm sure
I think you'd find out in history of legislative proceedings that has never
I don't doubt that at all. All I'm suggesting to the gentlewoman is it was done by a member who chose to do that, and they'll have a chance to reevaluate.
Would the gentleman yield to me as well?
Certainly.
Okay, I appreciate
Oh, I'm
that.
sorry, I don't have the time.
No, and I appreciate it. And look, just to state the record, I think questions are asked. I think it's not unheard of. You read the Jeffersonian Manual that actually is in there. If there's a discussion of if you support a bill and being a part of that. Now, that said, I think a member is able to add, and my friend from Georgia did ask tonight, and that's fine. I think it's a question that can be asked. Also clarifying the record, I never have. So, and so I think, and just to clarify that record, so again, I think there's a lot for us to discuss, but there's also, I think just the interest of where we go forward, and I think those are the kind of things that we're looking to go forward with. How do we move bills? How do we get the best interest of the people on both sides of the aisle to come to a conclusion that the American people are the ones at the end of the day that benefit or lose, and what we do or not do. And with that, I yield back to the
Well, just reclaiming my time, and I apologize to the gentleman. I don't remember. It may have been Mr. Severs. I thought it was you, Mr. Collins, and I accept the fact that it was not. But another member before Mr. Woodall tonight did, and I'll go back and peruse the record and bring it to you. But the points are made already that Ms. Slaughter and I have made. And as long as I've been here, I've not seen anything like that, and I don't think I would ever ask a member what their position is, and I don't know about Ms. Slaughter or Pete, but I do know that I've had of the limited number of amendments, and I might add a very limited number of amendments made in order, and I have voted for or against a measure depending upon the bill and its particulars. Thank you, Mr. Chairman. I won't delay.
I think these are favorable discussions. Yes, ma'am.
Yes, well, frankly, that doesn't really occur to me that much. In fact, I don't get amendments. You get some? Okay. But I really find it offensive. I mean, what if the answer is none of your business? I mean, we don't want to degenerate into here into something that's almost childish. If you don't say that we're not going to make that amendment in order, no matter how important it is, because we're not sure you'll vote for the bill. That's not democracy.
Yes, ma'am. Well, once again.
So I really object to it just on the face of it. I'm not, okay.
And I'm delighted that you not only had time to do it, but you felt comfortable in doing that. And this is how we deal with each other and try and get a little bit better.
Thank you for the
Yes,
time.
ma'am. Yes, ma'am. Okay, so here's what.
Mr. Chairman?
Yes, sir.
Since you're soliciting feedback, if I could be recognized.
Gentleman's recognized.
I would say that oftentimes folks have an opportunity to go back and reevaluate and change. Other times, folks have a chance to go back and double down on where they were and do it more often. That was not where I was going with that, and that may be a better lesson for reflection. If we are going to handle a more important appropriations bill than this one this year, I don't know what it is. And if anyone in this body is going to pursue their political agenda at the expense of funding our men and women in uniform, I say shame on them. I hope that's not the case.
I hope that's not.
I hope that's not, if reclaiming my time.
Yeah.
I hope that's not the case. Having just been through an experience where we passed a bill that was incredibly important, brought to the floor a bill that was incredibly important to my constituency, incredibly important, knowing full well that we had the votes on the floor to pass that bill and send it to the Senate to get this appropriations process back on track, and to have folks add amendments to that bill and then to celebrate bringing the bill down was offensive to me. There may be some folks in here who are here for politics, but the folks on this committee are here for good policy. We're better than creating a bumper sticker with a vote on the floor of the House. And I will say, if for this most important bill, most important appropriations bill we're going to move all year, someone would say to me, Rob, you know what? I have an issue that's near and dear to my heart. And I don't support this bill, and I don't intend to see this bill go to the Senate, but I want to add my amendment to it anyway. I would say, you know what, friend? I want you to be able to pursue your agenda. I celebrate having votes on the floor of the House. I was glad we got to vote on the Maloney Amendment to find out where the votes were. Candidly, I was surprised. I didn't know that's where the votes were going to go. But this bill can't be delayed because of a different agenda. This bill is about men and women in uniform and making sure that they are well-funded. So I would just say to my friends that I value their counsel, and I value their wisdom. I value the years that they have been here. But I want to be clear. This committee's responsibility is to move legislation to the floor. That's the only thing we exist to do. And I deeply regret that we're talking about changing the way we bring appropriations bills to the floor. I don't celebrate that. But we did that to ourselves. This body of 435, we did that to ourselves. And I would say to my friend from New York, I'd yield in just one moment.
When you finish there, okay.
I would ask for the respect and the courtesy that I think I've earned up here on this committee.
Of course you have. And I would ask for that same respect and concern for Mr. Maloney, a duly elected member of the House of Representatives who believed, and many of us believe with him, that discrimination in employment by the federal government was not a good idea.
Part of the respect that I would ask for would be not being spoken over when it is my time, which I did not do to Mr. Maloney.
I recognize that, and I apologize.
I thank the gentlelady. Our responsibility here is deciding which amendments get made in order and which ones don't. The very conversation that you want this body to have, I will tell you we're at risk at not having because folks consider it a poison pill. Far from doing harm to these witnesses today, I was trying to advance their cause because it is easier to make amendments in order on an important piece of legislation when you know that the folks who are bringing those amendments are not trying to bring the bill down, but are trying to push the bill across the finish line. I regret if anybody finds that effort offensive. This is a collaborative place. We only work in conjunction with one another. I intend no offense to anyone at all, but I will not relent on my commitment to keep this legislation moving across the finish line because I think it's that important.
Would the gentleman yield?
I'd be happy to.
Are you going to ask every witness that question?
Reclaiming my time, I'd say to my friend, I haven't figured out how this new day in appropriations is going to go. When we have a Republican conference meeting, I'm voting the other direction on this process. I'd like to see us have an open rule and see us be able to be the body that I believe that we are. But very thoughtful men and women can watch the episode on energy and water and decide that we're really not that thoughtful body. And those folks represent the majority of the votes these days, and I hope we can dispel that conclusion. Be happy to yield to my friend from New York.
I thank you. And our job here is to determine germaneness of the bill. And Mr. Maloney, I think deciding that you are going to be the judge of what Mr. Maloney had in mind. Frankly, it's the first time I've even heard the thought that Mr. Maloney was trying to bring down the bill. I thought Mr. Maloney was trying to, what he felt was to improve that bill. And frankly, I was troubled too by the fact that contractors are allowed to discriminate against gay, lesbian people on federal jobs. I'm not even sure that's constitutional. I didn't get into it that deeply.
Reclaiming my time for just a moment, I would
finish this part. All I want to say to you is that you have set yourself up as the determinant person of what anybody in this House writes in an amendment. That's not our job.
I would say to my friend, that's exactly what our job is. That's why they call it the Rules Committee. That's exactly what our job is.
We don't do independent rules. I couldn't make a rule. The fact is the rules are made by the House of Representatives, and we vote on them. I yield back.
I would say to my friend that, as she knows, there are a lot of faith-based contractors that serve our men and women in the field, and I know that she honors their work as I do, and would not suggest for a moment that those faith-based contractors do what they do out of hate. They do what they do out of love, and we're lucky to have them there.
Then let me respond to that. As far as I know, there's nothing about hiring somebody that you ask about their sexual preference. I don't believe that's what a contractor cares about. but they care if they're hiring carpenters, if they know how to measure and cut. And the idea of deciding that somebody's faith will allow you to discredit another whole group and say they can't work. I mean, I'm pretty sure that the founding fathers or nobody else ever intended for the Rules Committee to do anything.
Well, our founding fathers probably aren't going to be the best ones to look at
Well,
for that
I would
particular
doubt certainly
view,
the people of
but
the
I
United
take your,
States would expect.
I take your point. Mr. Chairman, I appreciate your indulgence. I yield back.
When are we coming back?
Is there any other debate before we go to questions? Any other debate? I thank the members for their thoughtful engagement. What we're going to do, I'll be real honest with you, I have no clue what time it is, but I think that the outside engagement normally is over a couple hours from now.
What is this plan? Picnic at the White House. Picnic at the White House. Okay.
We're trying not to hurt anybody's feelings. So as soon as we get through with that, we'll have an opportunity. So,
We'll hear from you.
yes, ma'am, you will. I can guarantee you will. So,
Thanks.
thank you very much. Is there anything else from our committee? The committee will now be in recess, subject called chair.
then he went to the Budget Committee, and then went to the Rules Committee.
Rules Committee will come to order, and thank you very much for joining us. We're back after a recess to finish the work on 5923, Department of Defense Appropriations Act of 2017. Chair will now be in receipt of a motion from the gentlewoman from Grandfather Community, North Carolina.
Thank you, Mr. Chairman. I move the committee grant a structured rule for further consideration of H.R. 5293, the Department of Defense Appropriations Act 2017. The rule provides that no further general debate shall be in order. The rule provides that the bill shall be considered as read through page 170, line 7. The rule waives all points of order against provisions of the bill for failure to comply with Clause 2 of Rule 21. The rule makes in order only those amendments printed in the Rules Committee report, amendments en bloc described in Section 3 of the rule, and pro forma amendments described in Section 4 of the rule. Each amendment printed in the report may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided, controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report or against amendments en bloc described in Section 3 of the resolution. The rule provides that it shall be in order at any time for the chair of the Committee on Appropriations or his designee to offer amendments en bloc consisting of amendments printed in the report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Appropriations or their designees, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule provides that the chair and ranking minority member of the Committee on Appropriations or their respective designees may offer up to 10 pro forma amendments each at any point for the purpose of debate. The rule provides one motion to recommit with or without instructions. Finally, Section 6 of the rule provides that it shall be in order at any time on the legislative day of June 16, 2016, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15, and that the Speaker or designee shall consult with the minority leader or her designee on the designation of any matter for consideration pursuant to this section.
Thank you very much. You've now heard the motion from the gentlewoman, the Vice Chairman of the Committee, Mrs. Fox. We're now ready for discussion or amendment to that. Gentlewoman from New York's recognized.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 5293 by Representative Fitzpatrick, number 38, which would prohibit the Essure medical advice currently under safety review by the FDA from being used on service members and their families until that safety study is complete. Representative Fitzpatrick and I had a bill that we did on morcellation, which was a medical device used on fibroid tumors, and many women got cancers. Cancer was spread throughout their peritoneum because of it. I really would appreciate very much if you'd consider doing this. It's a very important bill.
Yes, ma'am. The committee worked with him and the parliamentarian, and there was a point of order that did not get resolved.
Okay.
And Mr. Fitzpatrick, in fairness to you and me, has for a long time not only sought recovery of this very touching issue, but has stayed after me. I see Mike almost every morning, and he's most consistent about this.
Oh, he's worked very hard.
Yes,
on
ma'am.
it.
And
He really has. Now,
he is going to be sorely missed.
very appreciated. Yes, he is.
Yes, ma'am. Yes, ma'am.
All right.
Does the gentlewoman wish to push the amendment?
I certainly wish that we could
Okay.
give it a waiver and make it in order because it is an important medical issue.
Discussion about the slaughter amendment now that she knows that there was a point of order against the provision. All right, we'll now have a vote. Those in favor of the slaughter amendment signify by saying aye.
Aye.
Those opposed, no.
No.
Noes have it. Is there further discussion or amendment? Gentleman from Massachusetts.
Yeah, Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 5293 by Representative Maloney, number 17, which prohibit funds from being used to contravene the President's executive order pertaining to equal employment in federal government contracting.
Thank you very much.
And as far as I know, this is germane.
Is there any discussion? Okay, the vote will be on the McGovern amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Those have it, those
Ask
have
for
it.
a roll call?
Gentlemen, ask for a roll call vote.
Ms. Fox?
No.
Ms. Fox, no. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Chairman,
Clerk
no.
report the total.
3 yeas, 9 nays.
Amendment's not agreed to for amendment or discussion. Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Oh, excuse me.
I'm awfully sorry.
No, that's not a problem,
I was
Judge.
sitting here trying to
Judge-
get the
Judge,
order
you're
that I wanted
recognized.
to offer these. Mr. Chairman, I have an amendment to the rule. I move the committee make in order every amendment that would have otherwise been made in order under an open rule.
Thank you very much. Discussion.
Great idea.
Those in favor of the Hastings amendment signify by
Bad
saying
chance.
aye.
Aye.
Those opposed, no.
A roll call, Mr.
Those have it.
Chairman.
Gentlemen, ask for a roll call vote.
Ms. Fox? Ms. Fox, no. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 9 nays.
The amendment's not agreed to. Further amendment or discussion.
Yes, Mr. Chairman.
Gentleman's recognized.
I have an amendment to the rule, move the committee grant H.R. 5293 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Discussion about the amendment.
Very brief discussion,
Yes, sir.
Mr. Chairman.
Yes, sir.
I think most of us here in the appropriations measures would favor the old method of allowing for open rules. I've lost count, but I don't think we've had many open rules in this session. And I think that's a mistake, and I just want to be on record saying so.
Yes, sir. And I want to thank the gentleman, not in this instance, so don't hear me apply it this instance, but even this week, and several weeks before, we've had closed rules simply because we announced the amendment process and nobody had an amendment. So if it's indicative and sometimes not indicative of the statement, probably too many, and I don't want to take that issue on. I do want to say it's not unusual to have bills where we have had no amendments. Yes, sir, and I appreciate that. Further discussion? Those in favor of the Hastings amendment signify by saying aye.
Aye.
Those opposed, no. No, the amendment's not agreed to. Gentleman asks for a roll call vote.
Ms. Fox? No. Ms. Fox, no. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
Aye. Excuse me, no.
Mr. Chairman, no.
I'm sorry, we're starting to go through this. There you go.
Oh, my heart.
There you go. Clerk will report the total.
3 yeas, 9 nays.
Thank you. I'm all the way down the road. I'm halfway home, sir. All right. Now, we're going to go to the motion. Those in favor of
Let's
the,
have it.
motion from the gentlewoman from North Carolina signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes
And
have
we'd
it.
like a roll call.
Gentlewoman asks for a roll call vote.
Ms. Fox? Aye. Ms. Fox? Aye. Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall? Mr. Woodall? Aye. Mr. Burgess? Mr. Burgess? Aye. Mr. Stivers? Stivers? Aye. Mr. Collins? Mr. Collins? Aye. Mr. Byrne? Mr. Byrne? Aye. Mr. Newhouse? Mr. Newhouse? Aye. Ms. Slaughter?
No.
Ms. Slaughter? No. Mr. McGovern?
No.
Mr. McGovern? No. Mr. Hastings? No. Mr. Hastings? No. Mr. Polis? Mr. Chairman?
Aye.
Chairman, aye.
Clerk will report the total.
9 yeas, 3 nays.
The motion is agreed to, and accordingly, the gentleman from Mr. Byrne will handle this again. Thank you very much.
And I'll do it for the minority.
I'm sorry?
I shall handle for the minority.
The gentlewoman, Ms. Slaughter, will handle for the minority. Long day, thank you very much. This should complete, you know what, that's a very good question about the next week, and I would assume that the majority leader will be handling that in a discussion with Mr. Hoyer on Thursday. Yeah, I'm off a day. I come in here because of my intern programs, and I come here on Sunday night, where it seems like it's always an extra day for me. So yeah, it'll be on Thursday. It's Tuesday. Yeah, it is Tuesday today. I know. I'm learning, and this is 2016. Yeah. Okay. Thank you very much.